Hi, Greg. Greg is Public Policy Director at IAB Europe. He is the one that is dealing with all the DSA and DMA conversations on behalf of the European advertising industry, and he knows better than anyone about the details and how it affects our industry and what are the main points that we should take into account and we should follow in order to avoid like a very hard regulation. Thanks a lot, Greg, for being with us today, and the floor is yours.
Thank you very much, Paula. Good morning to everyone, and thank you very much for this invitation. This is surely a timely opportunity to take stock of the various policy discussions we have had over the well, in fact, more than almost, I think, 2 years, because we are at half of the EU institutional term of the EU institutions in Brussels. I would like to concentrate on our views with regard to Digital Services Act. We've been following and engaging with the EU policymaker on this dossier very closely. IAB Europe represents the broad digital advertising and marketing ecosystem, and practically that means that we would work with any party with investment in digital advertising or ones that benefit from it. So we may talk about a brand, we may talk about agency, technology companies that support delivery and measurement of advertising, and finally the publishers. And from that perspective, we've been very interested in the DSA, but also most concerned about some of the proposals that we have seen to ban or restrict primarily targeted advertising, but even more broadly, data-driven advertising. I think the DSA discussions in its totality, they demonstrated well that heavy restrictions on targeted advertising would have severe unintended consequences for a host of players, SMEs, smaller markets, really EU economy at large, and at the end of the day, consumers. And targeted advertising has proven to be an essential low-cost tool to help connect businesses with new customers or audiences, if we are talking about other types of organizations that may wish to use advertising to reach their goals. And I'm also thinking about not-for-profit sector, for instance. And indeed, digital advertising has been pioneering the better addressability of right audiences. So these are quite some questions around it, and we understand it. I also think my colleague Daniel will probably flesh out a bit better that problematic or that thematic, speaking about the value of advertising and digital advertising in particular. But this debate in the DSA has not been just about advertising, because at the end of the day, it's also about the free and open nature of the internet, media pluralism, and Europe as a hub for innovation. And advertising is the primary funding model that enables also traditional newspaper and magazine publishers to succeed in the digital era, because it makes up to 81% of digital revenues of those traditional publishers in the digital space. And we know very well, we have seen it also over the past 2 years now during the COVID pandemic, that digital is critical. So we have seen in the Parliament the finale of the discussion that there wasn't a decision to proceed with a blanket ban on targeted advertising, and this is clearly welcome. But we believe that policymakers must remain alive to the value of advertising and targeted advertising, among others, because we may risk that some of the remaining provisions of the DSA in the Parliament's text may have their introduction may have repercussions on a thriving digital economy for Europe's future. And so on that note, I would like to speak to four points, taking stock a bit of primarily of what we have arrived at with the text agreed by the European Parliament in the first reading, but then also looking at what the original proposal provided for, what it was actually scoped for, and tested during the impact assessment phase. The work done by the European Commission, and eventually also what the member states, including Spain, for instance, agreed to in the Council's general approach. I would just say that we have been consistently warning of an overlap with the existing law, in particular EU privacy and data protection legal framework, and consequences thereof, including lack of legal clarity for the business that seek to comply with the law, and perhaps impact on the enforcement law. So this would be probably part of my remarks. But indeed, the first point that I would like to make is that we have taken a good note of the importance attached by the EU policymaker to ensuring a sufficient level of transparency in digital advertising. And this attachment aligns to our own, as reflected in the range of industry initiatives, be it IAB Europe's initiatives, national IAB's initiatives such as IAB Spain or others. There is a need to enhance transparency, enhance trust, and that will be good for both in the business to business paradigm, but and also eventually for the consumers in the B2C world, if you like. So with that in mind, I would like to reaffirm our commitment to enhance transparency as originally proposed by the European Commission under Article 24 of the proposal, and as also upheld by the member states in the Council's general approach. Now, moving on to the three remaining points where I may be somewhat more critical. We think that one should look at them with a critical mind, assess them in that manner. I would like to speak to Articles 13A. As well as 24.1a and 24.1b from the Parliament's text. So when it comes to Article 13a from the Parliament's text on the online interfaces design and organization, the so-called dark patterns article, we are quite worried that some of the provisions included in that. In that article would likely take away the right of publishers to independently hold a dialogue with the user on consent for advertising purposes. This is evident from subpoint 1.1e, and I believe we in fact talk about there. The text stipulates any kind of processing, so that would be beyond advertising specific purposes, and that will heavily interfere with existing provisions in the EU consumer law, but also data protection framework, with the latter already being interpreted and applied by the data protection authorities. I should also say that when it comes to the EU consumer law, we have just seen the European Commission releasing guidance on the application and interpretation of the Unfair Commercial Practices Directive, which seems to capture well some of the aspects discussed in this article, and I would also remark that we note that in the Council's general approach, there is a reference to the so-called dark patterns, but it goes only as far as designing the online interfaces of online marketplaces. So this is a specific tailored approach to this matter in question. and this is at variance with sweeping and far-reaching stipulations under Article 13A from the Parliament's text. Moving on, when it comes to Article 24(1)A, and there are also related stipulations under Recital 52, under amended Recital 52 from the Parliament's text. We have seen some last-minute additions based on amending language proposed in the run-up to the final plenary vote in the Parliament. One could label those as speaking to consent and access to service, and there also we see likely overlap with the existing legal framework and the several DPA's guidance on the consent legal basis, including in the context of the provision of ad-supported content and services. It is important, we believe, that any such interpretation of the GDPR requirements is made on a case-by-case basis, including taking into account the context of different business models. And I think by now we even have certain case law related to this. In 2019, I believe, or 2020, we saw quite an important decision by Conseil d'État in France, where that point was highlighted, and we believe it's the right way to go. Adding new overlapping and possibly contradictory language on the matter of obtaining consent would really be damaging for the GDPR and would render possibly DPA's efforts to date as irrelevant. And we also note absence of any such provisions in the Council's general approach, as well as Commission's original proposal, which begs the question whether such stipulations have been really thought through and sort of tested, if you like, during the preparatory work before the proposal was even drafted. Finally, the last point I would like to make on substance pertains to Article 24(1)B, and again related stipulations under Recital 52 from the Parliament's text. So there we are seeing, put simply, a ban on targeted advertising to minors, as well as based on special categories of personal data. There are quite a few practical questions concerning the implementation of such provisions. They remain, even though I think there has been quite a heated discussion around that, and many questions surfaced in the run-up to the plenary vote of the Parliament. There would, if any such provisions were to be adopted in the final text, there would need to be reassurance that one can actually verify users' age. Or users' age. Otherwise, we actually risk a de facto blanket ban on targeted advertising, or maybe more broadly, data-driven advertising. Interestingly enough, we have also seen now a Commission's proposal on how to regulate political advertising. And that also touches upon the matter of the so-called sensitive personal data already regulated under Article 9 of the GDPR. And the Commission usefully reiterate the importance of the GDPR and the rules that are in the regulation. So we might end up, if the Article 24(1)B with that ban on special categories of personal data would go through, we might end up with certain dissonance where we have very, very different interpretations of the already existing rules taken differently depending on the legal text. And once again, I would note the absence of any such provisions in the Council's general approach, as well as the Commission's original proposal. So here one should ask this pertinent question: on how to proceed. I think I would like to would like to wrap up this point on the substance, stating restating our call, where we have urged caution on some of the amending language proposed by the Parliament that ended up in the Parliament's negotiating position on the DSA. A number of these provisions, as it was hopefully evident from my remarks, give cause for concern for all those who support an efficient, secure, and prosperous European digital market. And once more, it goes definitely beyond just digital advertising space, because it will have repercussions on how users consume content online and access a variety of services. So with that in mind, I would like to conclude my remarks. I look forward to hearing more during the course of the event, and would like to state once more our general openness to engaging on this important dossier, and more broadly digital policy with the EU policy maker. Thank you.